Okay, we'll jump into it. Welcome. This is my masterclass. This is a series that's been run by LexisNexis, and this is the first of them. Our focus today is on the impending insolvency crisis and its impact on the legal profession. Today is also the International Day of Democracy, and it's part of our commitment for upholding the rule of law that we're running these masterclass sessions. So my name is Greg Dickerson. I am the Managing Director for LexisNexis in the Pacific, which focuses on Australia, New Zealand, and the Pacific Islands. Before I introduce the panel, I'll just go through a few housekeeping items. First and most importantly, I'd like to show my respect and acknowledge the traditional custodians of the land, of elders past and present, on which this meeting takes place, obviously virtually, but around the country. If you want to, you can ask questions. The way you do that is to click into the bottom in the Q&A little box there. And in that, you can ask a question. We will be looking at the different questions and voting up those that we see that have been the most votes. So if you see a question that's already been asked that you see is something that you'd like to focus on, do an upvote on the question rather than retyping your own question. That way it'll surface and it'll be something we can talk to in the process while we're going through that. Also, if you want to post or have any comments post the session, use the LexisNexis Masterclass hashtag, which you can see just to the, I think that's the left of me, might be the right of me. You can see that, use that if you want to, and you can continue the discussion on social media channels. So first off, I'd like to introduce our speakers. Very excited about the speakers we've got today. And I'm very excited about this conversation because they're both, well, all three of them are quite immersed in this area of the law and what's happening now. And I'm very, very sure that the conversation is going to be pretty exciting. So first off, Professor Pamela Hanrahan. She is a lawyer, legal academic, and author who specializes in corporate law, corporate governance, financial services regulation, data governance, and business ethics. She's Professor of Commercial Law and Regulation at the University of New South Wales, a Senior Fellow of the Melbourne Law School, a member of the Centre for Law Markets and Regulation at UNSW, an Associate of the Centre for Corporate Law and Securities Regulation at the University of Melbourne, and a Founding Director of the Cybersecurity and Data Governance Research Network at UNSW. She's also a founding member of the Society of Investment Law, a fellow of FINSIA, a solicitor member of the Law Society of New South Wales, and in 2019 was the Glasgow Law Fellow at the University of Glasgow School of Law. Second speaker is John Winter. John Winter is the CEO of ARETA, the Australian Restructuring, Insolvency and Turnaround Association. Since 2014, John has taken the lead in ARETA's advocacy and thought leadership work, funding many parliamentary inquiries and working collaboratively with lots of different stakeholders, in particular Treasury, the Attorney General, Productivity Commission, ASIC, and AFSA. A lot of this has been around policy development, and you may have seen John is very vocal and seen him out there. He most recently did a great interview on ABC. John has also been a member of the Macquarie University's Departmental Advisory Board, and to the Department of Accounting and Corporate Governance since 2011. And he was previously the head of the Association of Chartered Certified Accountants, Australia and New Zealand. And our third speaker or participant is Tom Reed. Tom is the leader inside LexisNexis for our practical guidance modules around insolvency. He has an extensive experience practicing as a lawyer, and he worked for Minter Ellison for 18 years and 2 years at a global law firm in New York. He was focused on insolvency and commercial litigation. So welcome speakers, it's great to have you here. Now our speakers are going to be focusing on some of the developments in both the laws and the outcomes, which is very important, what's actually happening in the market since the onset of COVID-19. So we're going to be focusing really on this year, but also then on what is the outlook for next year. What are we going to see in 2021 and what may happen? Now they'd like to caution all the people participating and the audience that if you don't have a background in insolvency, consider very carefully whether you want to get into this space. It's a very, very complex and technical area of law. And as John says, if you think there's a simple answer in Australian insolvency law, you're not actually asking the right question. So it's great to have you here. Just before we start the questions of the conversation, I'd like to throw up a poll just to ask the audience, what area of insolvency law do you wish to upskill in? This will help us be able to more adequately guide the conversation. So if you can answer that, and then at around 12:30, we will be jumping on and having a look at where the poll indicates, and then we'll be looking at maybe guiding the conversation there. Excellent. So my first question then is for Pamela. Check that you're on, Pam. Give me 1 second. Apologies, I'm having a little bit of trouble with my IT. It might just be... I'll be 1 second. Okay, thank you. So Pamela, if you don't mind just taking a little bit of time to look at the big issues in insolvency law and what are lawyers grappling with now, since the onset of COVID-19. There's been so much changes and the law itself has been changing so rapidly. What are the big issues that we're seeing?
Yeah, thanks, Greg, and hello, everyone, and welcome. I hope this will be a really fruitful 45 minutes for all of you. I think what we're seeing at the moment through 2020 is that, as John will mention, many businesses that would in the ordinary of course have become insolvent or been terminated or closed are actually holding off because cash is flowing into those businesses from various forms of government support. And so we're in what I've described as the phony war. So we know that we're in recession and that the ordinary course of a recession is that businesses that were viable in the past, either because they had a sustainable business model or their financing arrangements were sustainable, are not going to be anymore. But we're not seeing that come in. So I think the big issue for corporate lawyers and corporate governance people at the moment, as distinct from insolvency practitioners, is what do I need to be careful of with my clients, realising that, maybe at the end of this year or into the first part of 2021, they are going to be in a situation where they may be in insolvency and they may be coming into an administration. So what do I need to be thinking about now to make sure that I'm not counselling my clients to do or allowing them to do that's going to create problems when that next wave hits? That's the biggest issue for us at the moment. So, and the government is sending a few mixed messages around that. So the various things that they've relaxed, like the insolvent trading laws, statutory demands and so on, which have got a bit of press, have perhaps suggested to some clients that, no, it's okay, you can just go into hibernation and there's no adverse consequences for just holding fire till the end of the year. But that's the biggest risk, because we know that insofar as the safe harbour for insolvent trading for directors, it does what it says on the can, but that's not much. It doesn't relieve directors of their ordinary responsibilities, their duty of care, their duty to act in the best interests of the company. And at a time where creditors' interests are very much to the fore, they do need to be focused on that. So I think the biggest issue for those of us who aren't insolvency specialists at the moment is, how do I make sure that I'm not making it worse for my clients when, the other shoe falls and in the beginning of next year they are starting to look at transactions that have been going on through the course of this year? How am I sure that they're not getting a false sense that, oh, well, the government said it's fine, I don't have to pay my creditors, there's no problems, and get a nasty surprise when they discover, for example, their personal liability for tax debts or so on. So I see that as kind of the biggest issue for the legal profession right now. The other issue, and I don't want to go past that before I hand over to the others, is the majority of solicitors, at least in New South Wales, where I'm a solicitor, are actually small businesses themselves. And so you can be very busy, but if your clients aren't in a position to pay for that work or aren't paying in a timely way, then you're probably worried about your own viability and your own sustainability in your own business at the moment. And managing that stress and that risk as a business owner for solicitors is really important as well, I think.
I agree, and I think it extends past just solicitors. It's anybody who's operating in the current environment. Do you know, if you're a healthy business, are your partners, or your customers, or your suppliers, are they actually healthy, and how do you even check? Yeah. John, so switching over to you then. So do you see the temporary suspension of insolvent trading since March? This insolvent trading liability, that temporary suspension, which has now been extended. Was that a good strategy of the government?
It was a really interesting strategy, Greg. I mean, it's an absolute emergency measure, and what we saw at that point of time was the government moving at almost light speed to come up with policy to put a very big band-aid over what was a crisis that we expected to go much, much deeper into.
Yeah.
And for the first time ever, we saw government bringing in law that would have taken 2 years from the point of conception through drafting, through exposure, through negotiation, through Parliament. That was coming to life within 48 hours. And so it's quite unprecedented in the way that was brought together. And so what it means is pretty rough and tumble. They really brought the sledgehammer in to crack the walnut. And so the government really had in its mind to look at sort of the 80-20 rule. Let's try and protect 80% of businesses as best as we can, as rapidly as we can. And we know that 20% are either going to abuse it or won't understand it, et cetera, et cetera. So it really was bringing that sort of blunt force instrument to try and solve the problem. What it was aimed to do, I guess, Greg, is send a real message to the business community as a whole that you can be protected through this complete unknown as it was at the end of March. And so that signalling, I think, was the main intent, less so the policy outcome. It's really important to realise that there's only a handful of insolvent trading actions that actually make it to court in any year. You can count on one hand. In fact, you can probably count on two fingers. The main mechanism that insolvent trading laws used is as a negotiating tool by liquidators to deal with individuals, individual directors, or to ping their professional indemnity insurance. So very little of it actually ends up going to court. Very little of it actually ends up with major enforcement action being taken against directors. But nonetheless, that signal was sent. And it did have a very binary effect. We saw behaviour change overnight. So where insolvency practitioners were dealing with a significant and increasing amount of inquiry coming into them as COVID started to unfold, it was like a light switch. The level of discussions absolutely ceased on the Monday. And so it had the desired effect, but it also had unintended consequences.
John, currently we're seeing insolvencies running at approximately 50% at a rate compared to the same period last year. So I'm assuming there's been a lot of less work around for your members this year, which you've just touched upon, but also let's assume looking forwards into next year. I know ASIC has raised a concern about whether the reverse might apply and whether there may not be enough registered liquidators to cater for the expected tsunami of liquidations. What are your views about the ability of the profession to cope next year with that?
Yeah, look, Tom, this is an issue we've been talking to government about, and look, it's a sore point for us because if you go back 2 and a bit years ago, there were 720 liquidators in Australia. We're now down to 620. That occurred almost entirely because ASIC brought in its industry funding mechanism at the direction of the government, quite clearly. But that fee is an average of $13,000 per individual practitioner. And going to Pamela's point, the vast majority of insolvency practitioners work in small businesses themselves. It's a huge impost. They actually don't even know how much they owe, and it could be anywhere from $5,000 to $40,000. They really don't know until up to 18 months after they've incurred that cost. And we said at that time to government and to ASIC that it would drive about 20% of liquidators out of the market. Well, we're a little bit off. It drove 17% out of the market. And now ASIC and the government are surprised that we might be underweight in terms of registered liquidators to manage this tsunami of work that's coming. Are we concerned? Well, there's ways that we can manage that. And we're talking to government about possibly increasing, at least on a temporary basis, some of the compliance times, for meetings of creditors, etc. Ways that we can actually take some of the sting out of the workload. But we're also working closely with the profession to try and make sure that they're able to upskill people very, very quickly to get them to do the work. But there's no doubt it's going to be a challenge. It would have been a challenge regardless of that backstory, but the backstory is a significant and problematic one.
I think what's going to happen is that a lot of the liquidations will be at the smaller end of the market, the small to medium enterprise, and we'll find that John, a lot, as your members will know, a lot of these companies will have no assets at all. So what sort of pressures is that going to put on your members to deal with the unfunded liquidations?
Yeah, Tom, that's a really important issue, and to be honest, the government has no answer to that. So for many of the people on this call, you wouldn't be aware that liquidators only get paid if there is sufficient assets in the job for them to draw the remuneration. And when so many businesses are going to be completely without assets, indeed very heavily into the negative territory, an insolvency practitioner is going to take that job and realise that they're already making a loss. But by the time they pay ASIC fees and do all the necessary compliance work, even on a basic job, they're already $10,000 in the red. And so that is a huge problem. And indeed, court liquidations, less than 1 in 5 of those used to have enough money to pay the liquidator in. That population of 720 liquidators used to write off $100 million a year in unrecoverable fees. So it's an extraordinary deficit that they start behind to have to work through that. One of the things we are concerned about is, quite rightly, liquidators are likely to look at this post-COVID environment and say, well, the government has taken steps which have further depleted the asset base of these insolvent businesses. I'm not going to take that appointment unless a creditor fronts up and says, here is a payment of a certain amount of fees in order to get you to start to do the process. And one wonders how many of those creditors will be prepared to do that. There's an obvious solution to that, and we continue to advocate this. The Assetless Administration Fund, which is run by ASIC and directly funded by the federal government, currently sits somewhere around $8 or $9 million. That's primarily used for anti-phoenixing. It's very difficult for liquidators to access. It costs them about $5,000 to access it, and they get about $5,000 back from it. But if that was a 10-fold increase, if we saw that sort of lifting in funding and a much simplified access for liquidators, you would get this work done, and it would still be the most efficient way to do it from a public policy perspective.
And John, do you see that as sort of the kind of, you talked about the rough and tumble of how we just jumped into some of these measures that the government's taken. Do you see this as the kind of things that they've missed? The assetless, it's a lovely word to say, assetless administration fund. Sort of those are the nuances which make it easier to be a practitioner in this space. And if you miss those nuances, you end up hurting the industry, not helping the industry.
Yeah, and this is exactly where the frustration comes from about the lack of engagement that government went through on these policies. And again, we respect the fact that they had a very strong view and an understandable view that they needed to deliver this stuff overnight. But the problem is when you run so quickly, you make mistakes. Everybody on this call would know that. And when, going to your early quote of mine about the complexity of insolvency law, if you're not getting the really smartest people in the room who understand this insolvency law back to front, you're going to miss these things, and the unintended consequences can be profound in this space.
Completely. Pamela, just throwing back to you, I mean, there's been quite a few changes. I know that the statutory demand's moving from 2,000 to 20,000, the time period going from 21 days to 6 months. Do you see that as being the major drivers for the fall in insolvencies, or are there other reasons? Is it, what is your thinking?
Yeah, so there's a couple of pieces in that, Greg. And the first is, you've got a real challenge in creditors being able to recover what is theirs. And if they don't have that power, how on earth are they going to start to take the measures to wind up the companies? And that's the simple part about it. If you have creditors unable to enforce their rights, you're going to place them in financial distress themselves. And that's one of the great challenges we're seeing in this space.
Yeah, completely.
Yeah, I think that's right. I think it's clear that government doesn't want to use the word business failure at the moment for a whole range of reasons, including just maintaining confidence into next year. But we can't just kick this can down the road, because for every debtor who's getting relief, there's a creditor who's not getting satisfaction on the other side of that. And the longer these arrangements stay in place, the more that contagion effect starts to pick up. And so a business that clearly, for whatever reason, wouldn't have been viable even absent COVID and the recession, is continuing to rack up debts to the detriment of those business owners who have personal liability, not just for insolvent trading, but for all sorts of debts. And in the SME space, are often have their personal assets pledged in support of the business debts anyway. So they're running a lot up. And the problem is that suppliers, including suppliers of legal services, of course, are continuing to provide services and goods on credit, and the extent to which we can do that indefinitely is very doubtful without pulling those otherwise viable businesses over with it.
Yeah,
I think that's going to be the strongest argument for possibly ending the protections on 31st of December, because I think the big question, or one of the big questions now, is will that get extended again? And I think the point against it is that the increasing debt levels of troubled companies is only going to affect good companies and spread the, as you've called it, Pamela, contagion. So I think the end of the year is going to be a critical time in terms of and the lead up to it is that are the protections extended, and also what other measures, legislative and otherwise, are going to be introduced. I know there's been certainly the Law Council of Australia and others have suggested that we need to look at other restructuring tools that we don't currently have, and whether we might be able to implement them on an urgent basis. It's never a good thing, but I think the times are unprecedented. People have pointed to the UK as being a model of something that we might follow. They introduced two new regimes in June, a moratorium scenario and also a creditor plan. But they also had a restructuring plan, but they also had an existing restructuring tool in place, being a company voluntary arrangement. And just for the benefit of what that might look like, should we get something similar, it involves the directors making a proposal to an insolvency practitioner, who's known as a nominee. The nominee files or makes a recommendation to the court, although there's no court hearing, as to whether there's a shareholder and creditor meeting. And then if it goes forward, there's a reorganisation plan proposed to creditors and shareholders to vote upon. And if the relevant majorities are met, then the plan gets implemented and unsecured creditors are bound. Now, John, what do you know about whether anything like that sort of debtor in possession regime might be being seriously considered?
And Tom, I might just extend that question, because it's come from the audience. Kate Broom is basically that question with a bit more, which is, John, what is the update do you have? We read the whole of reform around SME and the potential introduction of Chapter 11 style regimes. I suppose it goes to the UK question as well as, are there other thinking going on that you're aware of?
And I guess Tom has brought to light what we're dealing with out there in the marketplace at the moment. And that is that, unfortunately, there's a lot of thought bubbles going on, and not well thought through and cogent overlapping policy pieces. So if we go back to the middle of last year, Arita had called for and announced we were going to run a Financial Recovery Law Reform Commission. And that was because government over many years has failed to do so. We haven't had a proper review of the insolvency regime in Australia since the 80s, with the Harmer inquiry that brought in the voluntary administration arrangements. And if you think about business in the early 90s, 70s, it was radically different to what we deal with now. We had bricks and mortar focused businesses, and now we have a very definite service focused economy, a virtual business economy. So in many ways, we know that our system is desperately in need of some review. That being said, we continue to see the voluntary administration regime proving itself to be very flexible and adaptable, and there are great ways that it can be used to keep businesses afloat. There is a real danger in this sort of environment, and Tom touched on this, that you're going to have people going, I want to cherry pick this little idea out of the US. So I want Chapter 11, or I want to bring a CVA from the UK into Australia. And they do it through the rose-coloured glasses of distance. They don't stop to appreciate that Chapter 11 is a multi-stakeholder tool where you have lawyers for each of the creditor groups. It's court supervised. The court is in there at every point. It is a radically more expensive solution. If you think insolvencies are expensive in Australia, try Chapter 11. You'll get a bill shock. And then if you look at the regimes in the UK, CVA is a really good tool, there is no doubt. But liquidators in the UK do not have an investigations responsibility like they do here. Liquidators are the first line of ASIC investigations for any company collapse. The work is outsourced to them. You can't do that and run a CVA style arrangement. So if we're going to make changes, we need to go through a process of reviewing our regime, what we want it to be, where the balance sits between debtors and creditors. And we have one of the most creditor advantageous environments in the world here in Australia. Are we prepared to shift that as a society? And what do we want? Do we favour jobs over creditors, etc.? So those discussions are ones that need to happen with cool heads. They need to be deeply informed by policy and by stakeholder engagement. And you don't get that turned around in 3 months. And so the real risk here, and we continue to hear that government are very close to announcing at least a debtor in possession model for SMEs, that we think has got significant risks, because in Australia, most SMEs do not even ask for help until there's nothing left in the cupboard. You can't save a business that is more broke than broke. And so we need a cultural change to make that work. But we do expect the government is going to make some announcements in that space. What the content of that is remains a question. And I think when it sees the cold hard light of day, it's going to fall under some significant challenge.
And also the whole industry itself, is, as we start to ramp up, well, the question coming through is, you know, we've got potentially all these changes, and the regime at the moment will finish on the 31st of December, which is not the greatest time when you look at courts and the ability to, you know, so we've got an industry that is at the moment struggling because there's lower liquidations happening, and a regime that's potentially going to finish at the quietest time of the year from being able to get access into the courts. And Pamela, I might throw it to you. I mean, what do you think? Do you think the government's going to be forced to extend past the end of December, you know, to avoid the flip?
I think, yeah, look, I think there's significant resistance to extending beyond the 31st of December on any kind of rational basis. But that is not to say government might not be tempted for a range of political and other reasons to extend beyond the 31st of December. I think for those of us who have an interest in making sure that next year is not, you know, a complete bust, really have to be talking to government about saying, use this time between now and the 31st of December to pick up the things that you will need once these insolvencies start to flow. And that's not just legal mechanisms or resourcing in the insolvency industry, but it's also thinking about, you know, how are we going to support people who've lost their businesses to regroup, not go away and go into their shell, because we need people to be innovative. We need entrepreneurs to come back and reinvest. So I think the most important thing at the moment is really about discussing with business owners their need to be dispassionate in conducting a proper viability assessment of their business. So, you know, if we're in COVID normal for a while, do you reckon your business model still stands up, or should we be looking at doing something different? Because giving people a bit of hope for the future rather than just encouraging, as I think these measures have done, regrettably, people to bury their head in the sand a bit, ghost their creditors and ghost their advisors because it's all just too much to bear. You know, I think now is the time really to be saying to directors and business owners, you need to be spending this time between now and Christmas having a bit of a rethink. But, you know, should we still be doing this business? Should we still be delivering our goods and services in the way that we have been in the past? Because then when it does become time to make the legitimate choice that a business that's not viable in a COVID normal or in a post-COVID future needs to be closed, the business owners will be more psychologically prepared for that decision. And I think that will be really important.
Yeah. And I think it comes down, I mean, the overwhelming thing that I'm hearing from the whole panel is this need for us to be far more communicating with each other and working much more closely together, and also consulting the experts. It sounds like we've rushed to do things as a country, and potentially as a result, we've missed taking the time to talk to the experts, look at what the regimes are doing overseas, and try to come up with the sensible answer here. Yeah, and I know you don't have much time, but the wider and the more we talk about it, the more likely we are to come up with something that works.
Greg, just to pick that up.
When you think a lot of these decisions were made when the Prime Minister was still using the expression snapback, right? So it's not surprising that you would put in place an emergency measure really quickly. And as John has said, you know, I think there was a bit of 80-20 there where they said, look, we'll just put it in place and hopefully we'll get people over this first hump. The risk from a public policy point of view is if then you don't use that time to actually be having these hard discussions. So that's why it's fantastic that Lexis is running this, and we have so many colleagues on the call, because it shows that the professional advisory world is saying, look, we do need to start to engage with some of these more complex issues.
And that's a really important point that Pamela's just made. The government has had 6 months to nuance this policy, and all they did was roll it over. There had been no discussions about how do we come up with a transitionary arrangement. There had been no alternative proposals to smooth the curve. They just did the blunt instrument thing again and rolled it over, and may do the same. And that's concerning. And, you know, I did see one question coming up from one of the people on the call about the existing safe harbour powers. That safe harbour regime, it was about to have its first proper test. And our general view is it's pretty much fit for purpose. The law is only 3 years old. Now, the government were required, when that law was passed, to have a review of that safe harbour law 2 years after its commencement. That review has been sitting on the desk of the Assistant Treasurer since October last year. If they want to have a look at policy reform, there is a statutory need to fulfil that obligation, and you can certainly bring that to the fore and look at the wider issues around safe harbour and protecting business if you implement that requirement right now. And that's something we've been saying to government. You've got the mechanism, you've got the requirement. Let's get this discussion happening sooner rather than later, and let's get an informed decision that comes out of this.
Yeah, makes a lot of sense. I might, at this point, just pause for a second, give the audience a chance to have a look at the current questions or answer any more that are coming up, and maybe just throw it to the poll, and let's see what the poll results were. To the question, the big area that people are wanting to focus on is insolvent trading and the safe harbour provisions. 53% of our audience is most interested in that. Second is the personal liability of directors, which I think does go to exactly where does it stand now and what happens after December. And then the rest is in winding up in insolvency, unfair preference claims, which we haven't really discussed that much, and administration and deeds of company arrangement. Do we want to discuss a little bit about unfair preference claims, Tom?
Yeah, John, I understand there has been quite a bit of lobbying in some sectors to do something about what might be a flood of preference claims, perhaps in the mid to later part of next year, as a lot of these companies do go into liquidation, have been insolvent for a long period of time, and I think you'll find a lot of nervous creditors who might be in a position to rely on any defence, good faith defence, which is based on not being aware of insolvency. Do you think those lobbying efforts are being effective, and is there any realistic consideration being given to a legislative solution to that in terms of what might be a lot of preference claims next year?
Yeah, Tom, there's no doubt that there's going to be a flood of unfair preference claims. And for those who are on the call who don't understand the unfair preference regime, it is quite simply based around the notion that a liquidator's job is to look at payments that have been made prior to the collapse of the business, and particularly within the 6 months prior to the collapse, and ascertain if any of those have been made on a preferential basis. And particularly what they look for is related party transactions. But if there's an obvious awareness that somebody knew the business was insolvent and they pushed for a settlement of their creditor claim, then that should be tipped back for the benefit of all creditors. Now, indirectly, that also goes to funding a lot of the work that liquidators do, that recovery process. And so one of the things that the government is very aware of is that if you unpick that part, you will further unfund the insolvency profession and its ability to do work at the time where we are more unfunded than ever. So those businesses that we spoke about before that have become more broke than broke, on top of that, you're going to have the fact that the insolvency profession's had no work for 6 months and is struggling through itself. All of those things will create a bit of a perfect storm. The government is well aware of the implication in that. Now, we should also address the fact that the majority of unfair preference claims actually go to the ATO, because the ATO, through its payment arrangements, is well aware of whether or not a firm is in a likely insolvent situation. The majority of the other insolvent trading claims go against related parties. So we don't tend to see, in mass, significant amounts of unfair preferences being paid, particularly to SME creditors, etc. Nonetheless, a liquidator's job is to chase all those down on the pari passu principle and get them back into the insolvency process. So there's a lot of conflicting issues in here. The unfair preference regime is not without its problems, but it is one of the very obvious examples, Tom, of if you pull this apart in the heat of the moment now, the consequences will be profound.
The other thing I wanted to mention is as to whether the door is open for the more unscrupulous pre-insolvency advisors at the moment, particularly if there may be a long period before liquidations, and whether they might be quite active at the moment in sort of phoenixing type work. We did have the new anti-phoenixing laws commencing in February this year. Are your members telling you anything about whether they're aware of this activity going on at the moment?
Yeah, it's epidemic, and that's a pun intended comment, Tom. It is really bad. All you got to do is go into Google and type in "I'm going broke," and you will see at the top of the Google list a whole bunch of unregulated advisors who almost unashamedly tell directors how to steal money out of their business as it's collapsing and put it beyond the practical reach of creditors and of insolvency practitioners. These are halcyon days for dodgy advisors. Not only are regulators distracted by all the other issues that are going on, the process of liquidators going into so many of these jobs completely unfunded will create greater opportunities for them to trade their wares and strip the assets out of those businesses. So we do keep flying the flag for this. We know that illegal phoenixing costs somewhere between $3 and $4 billion a year to the economy. There is no doubt that number is going to elevate radically as we go through this process, and at a time where the economy can afford it even less, where creditors can afford it even less. So it's a significant problem. One of the things we continue to tell government that they should address is to regulate any provision of insolvency advice. And it goes back to Greg's opening comments about the complexity of insolvency law. This is not a space you want to tread in unless you really know what you're on about. And the fact that you can go out, you can't go out and give advice about financial products without an AFSL, yet you can go and give advice about insolvency law without having an obvious registration. That's a real problem for our economy. And it is something that's quite easily fixed. Bring in an AFSL style arrangement for this space. You've got registered liquidators, you have lawyers who are qualified in this space as well. It's an easy solution for government to try and fix this problem before it gets really out of hand.
And John, that probably goes to the most upvoted question we have from the audience, which is how many SME businesses, we know lots of SME businesses, first time they're going to actually speak and engage with the insolvency regime. So if you're a normal practitioner giving normal advice to an SME, maybe I'll throw this to Pamela, what do you do? How do you best support your customers? Also taking into account that they might not be able to pay you. So you've got to be able to weigh up your own financial security.
Yeah, look, I think you have to be really careful because for most of us who've got an ongoing relationship with clients, the desire to support those clients in difficult times is really strong. But there is a risk both for you as a practitioner and for the clients if you are not properly resourced or skilled to do the work. So I think that's why spending the time between now and Christmas, because I don't think we're going to see lots of people making either steps to move into the existing safe harbour for workouts or to appoint administrators. I think that's not going to happen between now and Christmas. But spending that time talking to clients about saying, look, the decisions that you make now can come back in 6 months when you do go into liquidation. All of these transactions and decisions that you've been making during this period are subject to really strong scrutiny. So for us, focusing on things like the director's duty to act in the best interests of the company and what that means at a time when creditors' interests rather than shareholders' interests are very, very much to the fore. But also the desire, particularly in SME, for directors to protect what is often the family wealth and the family jobs is very strong. And so assisting people to understand that they're not doing their stakeholders any favours by, going down this pathway where somebody seems to be offering a ready path out, just helping people to really say, if it sounds too good to be true, it probably is. If it sounds, as John says, like there's a simple solution to it, you're probably wrong. So let's just make sure that we're being really methodical and thinking about the fact that all of these decisions that we're making now are going to have to be reviewed down the track.
Yeah, completely. I might just go through, I know we've only got a couple of minutes left, but I might go through some of the top questions. So just a quick one for you, John. Litigation funders, what role do you see for them, especially with assetless SMEs?
So this is another great example of what happens if you change law too quickly and don't engage properly. So the government brought in some significant changes to litigation funding arrangements. One of the areas that was meant to be carved out was litigation funding of insolvency recoveries. And it was in all the explanatory memoranda that was an intention, yet when the legislation was drafted, it doesn't work. And indeed, it's now very hard to get insolvency litigation funding in place. We are working very closely with ASIC and Treasury at the moment to try and have that addressed. But unfortunately, that's going to require an amendment via the Parliament. So right now, there is a significant stop work around that factor, which is really unfortunate because, of course, litigation funding in Australia was born out of insolvency recoveries. And it's a vital tool to use this sort of extended funding to enable liquidators to go in and pursue those sort of recoveries. And so particularly they're going to be around related party transactions and trying to make sure that you're not engaged in phoenixing, etc. So there's a strong public good need here. And the government urgently needs to fix this. It was simply a drafting error and it's pulled the whole thing apart.
Yeah, that's a real pity. Maybe I'll just do the last question then, given that we've got a minute left. And John, this is to you. Whose responsibility do you think is it to identify businesses that are trading insolvent with little help? Who does it fall to?
So I guess the issue is, well, why are you trying to identify that they're trading insolvent? So the question is, where does the question itself come from? Liquidators will identify whether or not insolvent trading has occurred. I guess the other side to that question is, as a creditor, is insolvent trading occurring? And this is one of the big pieces that a lot of advisors on this call will want to know the answer to. And you've got to look for your classic signs of insolvency. It's people forestalling payments. It's at the whole difference in their trading patterns, etc. Those are the signs that you've got to look for. And credit managers are very wise to this. They know to ask very probing questions. They will want to get evidence that the business is actually viable before they're extending trade credit terms. And so there really is two sides sides to this. There's the forensic side, and then there's the ongoing business relationship side, because you want to be assured, so you miss the unfair preference claim later on, that you've got a business which is viable, and you can reference that if a liquidator does come knocking later.
Oh, that's a very
Yeah, and I think, Greg, that the role of directors in this is absolutely crucial. So the directors, the policy reason behind the insolvency trading laws, full stop, is to make sure that directors are keeping a very close eye on the trading position of the company. And so at a time when you're under a lot of personal stress, that can be a really difficult thing to do. Sitting down in front of the computer and opening the balance sheet, you know, and the cash flow statement every morning is not a good thing to do, but really emphasising to directors, this is your responsibility. You know, this is your job as directors to monitor the financial position of the company, to be satisfied that if you are incurring new debts, that you're in a position to meet those obligations, because otherwise, not only have you got an insolvent trading problem, but you've got a director's duties problem as well.
Yeah, and you did that. You don't escape those because of the safe harbor provisions. Okay, we're out of time. Thank you so much, Pamela. Thank you so much, John and Tom. This has been a very interesting conversation. I think we could probably have a session 3 times longer, and we'll look to maybe redoing one early next year and seeing how some of the crystal ball gazing we've done here and some of the challenges we've envisaged, how they work out, and hopefully we work much better together as a community, and especially supporting the liquidation, the administration professionals, and the general legal industry, so that we can get through this time in the healthiest way possible. So thank you very much for your time, and thanks for the participants. We had well over 500 participants on the call, and this will be recorded, and we will share this post the call. Thank you very much, John. Thank you very much, Pamela.
Thanks, Greg.
Thanks, everyone.
Everyone.
Thank you.
Thank you.